Let us find out if all of our speakers, the ones that participate in the second session, are there. Do we have Mr. Kravchuk in place? Mr. Volodymyr Mykolaievich, can you please respond to us? Mr. Volodymyr, are you there? Please turn on your microphone. Ms. Natalia Blazhievska, welcome. We can see you online. Excellent. Mr. Volodymyr Kravchuk. Mr. Georgi Popoashvili, are you there with us? Please make sure that Slavica Banich can hear us. Mr. Bashek Wojciechowski. Everyone is in there. I haven't heard Volodymyr Kravchuk's reaction. He is there. Welcome, Volodymyr Mykolaievich. I greet you too. Hopefully everyone is ready. Greetings and welcome to all of the participants of the second panel discussion. We are also welcoming and greeting the participants of the first session and provoked a lot of new questions for further discussion. Maybe in some way, we will also revert to comments provided in the first session because unfortunately time was limited and it looks like the interest is really hot and it still remains. I would like to remind everyone that today's topic is legal consequences of the Declaring Normative Act as unconstitutional for protection of human rights in the administrative legal proceedings. And as you know, my name is Miroslava Bilak. I'm a judge of the Administrative Cassation Court within the Supreme Court of Ukraine, and I will be moderating today's event. I would like to focus your attention on the point that in session one, we determined that retroactive effect should be there, and therefore another question ensues. How should it be implemented in the judiciary practice in order to help to restore justice? And be reminded that in the previous session, we said that according to Constitution, laws and other legal effects do not have retroactive action in time. And the decision of the Constitutional Court, again, they become non-constitutional, that is ex nunc, and they act pro futuro, for future. And the main risk in this respect for implementing ex tunc is the legal certainty. In Article 152 of the Constitution of Ukraine, which enshrines and determines the legal nature of the decisions of the Constitutional Court, it talks about the possibility of compensation for material and moral damages in case of recognition of a law or other legal act as unconstitutional. And in fact, this determines the application of the retroactive effect of the decisions of the Constitutional Court. There is a point of view in the professional environment that decisions are not promising enough, especially decisions of the Constitutional Court sometimes. They are not enough, insufficient, and the renewal of human rights must take place from the moment a law or a regulation is passed, something that one of the presentations, Mr. Savchin, in one of his presentations highlighted. Mr. Savchin, in his written presentation, gave very important food for thought for the discussion in part one. So it can thus be embodied as ex tunc, as a form of retrospective application of retroactive action of a resolution. This raises the important question of when a legal relationship arose and at what point a person actually faced injustice as a result of an adoption of an unconstitutional law or other legal act from which a person requires compensation because they have been wronged and they want moral and material damages to be compensated. The absence of a clearly defined reimbursement procedure does not prevent one from applying to a court. And in my view, the court has enough authority and competence to resolve such issues. The Administrative Code of Cassation contains a procedure for reviewing decisions in exceptional circumstances according to which a citizen may apply to an administrative court with the request to review a decision in exceptional circumstances as a result of declaring it unconstitutional. It says, first of all, about Articles 361, 363 of the Code of Administrative Proceedings of Ukraine, which caused a lot of questions in the particular practical plane. That is to say, can we review cases based on a decision on constitutionality on which a final decision has been made? Or should we only review cases in which a decision has been made but not yet enforced? What about a decision that may not be legally enforced for months or sometimes years? How to determine for what period and to what extent a person should receive compensation? So our session will be devoted to these practical issues. And now I would like to officially announce the participants who will participate in section 2, in panel discussion 2 of our workshop. Mikhailo Smakovich, the president of the Cassation Court within the Supreme Court of Ukraine, Volodymyr Kravchuk, the judge of the Cassation Administrative Court of Ukraine, Natalia Blagievska, judge of the Administrative Cassation Court of the Supreme Court of Ukraine, Georgy Popoashvili, professor, former president of the Constitutional Court of Georgia, former Minister of Justice of Georgia, expert and former member of the European Commission for Democracy through Law, Slavica Vanic, former judge of the Constitutional Court of Croatia, former substitute member of the European Commission for Democracy through Law, Bartosz Wojciechowski, judge of the Financial Chamber, Supreme Administrative Court of the Republic of Poland, PhD in law. Now I would like to stress for our audience who remain in touch with us online, I will not be speaking about the structural elements of today's program, something I spoke about in the morning because our audience remained the same and I don't think it's necessary to be reminded about it now. The only thing I would like to encourage our audience to get activated and again get involved through the survey that's going to be posted for you right now on the screen, so that we can further see the dynamics of your answers to the same questions at the beginning of the session and whether we will be able to change your attitude, your opinion at the end of the session. And maybe this will allow us to be more specific about certain points of our discussion in order to find better answers and perhaps to provide proper responses depending on how you are voting now. So the question that we have in the review, so what is your idea? Do we have in your opinion, the most effective way to restore human rights following the application of an unconstitutional act is to review the decision on the basis of exceptional circumstances, or to compensate the claimant through pecuniary and non-pecuniary damages, or to do nothing? Please take your vote. In answer to the question concerning restoration of human rights, as a result of an unconstitutional act, it's better to reconsider this in connection or in light with exceptional circumstances. 78% of the audience voted in favor of this option, in favor of this revision by compensating pecuniary and non-pecuniary damages. This was the option taken by 20%, and do nothing at all is 2%. In favor of that. Therefore, as we continue discussing, we'll be able to talk about some of these comments more at length in the context of this vote and this survey. And let's see how the dynamics of the survey changes during the second time we vote our survey. We have our survey. Now, I suggest that we go to watching the videos, topical videos that were specially pre-recorded, in which our speakers again would make certain opinions concerning the topics touched upon in session 2. Рішення Конституційного суду мають дуже важливе фундаментальне значення для відновлення порушених прав людини та правовідносин в цілому. Для прикладу, у нас
asking to declare unconstitutionality of the legislation which prohibited to reopen the cases of ordinary courts in administrative and civil cases after the decisions of based on the decisions of.
Для прикладу, у нас був дуже цікавий випадок у Конституційному суді Грузії, коли одна з телекомпаній звернулася до суду.
Пані Олена, перемкніть канал.
Так, зараз будуть переглянути.
Citizens or legal entities. So it's interesting that it's all more than 4 years and the Constitutional Court couldn't reach the final decision. And it shows how difficult it is for the judges to define this, the final approach to the problem. And it was interesting that when I was still in the court, the draft decision was almost ready by the judge reporter 3 years ago, but most of the judges were not ready to deliver their opinion for that. So the court asked the Venice Commission in 2018. Venice Commission provided amicus curiae for this case, which would be interesting for all the participants for all the other countries, especially for Ukraine, because Ukraine a few years ago they changed legislation. Unfortunately, the Ukrainians introduced the individual application system, which gives a lot of room for individuals to apply to the Constitutional Court to redress the constitutional rights violations via, including via Constitutional Court. But of course, it's not a full-fledged constitutional complaint system, but still it's very powerful now for the Constitutional Court of Ukraine. So there are two major approaches about the effects of the Constitutional Court effects. First is ex tunc effect, so-called, which is more German model, where the decisions of the constitutional courts have retrospective power of all the judicial decisions have been adopted before the decisions of the constitutional court. And this is very rare case. It's just German model. You can say that Moldovan case could be a bit closer because the Moldovan constitutional court struck down a few years ago the legislation which prohibited reopening the cases in civil dispute. So Moldovan legislation practice can be a bit closer to German model, so-called ex tunc effect model. But in most of the countries, we have ex nunc model, which says, which provides that the decisions of the constitutional courts have no retrospective effect, but they affect the decisions of the judicial decisions, administrative decisions in civil and administrative cases, just decisions rendered after the decisions adopted by the Constitutional Court. The typical example is Austria, which provides such case, but there are some variations within the system. There are two cases, for example, one when there is a time limitation and when the retrospective power is still in force, like in Armenia, if the decision is made to declare unconstitutional legislation, this decision is the basis for reopening all the cases adopted by the ordinary courts during the last years for adoption of the constitutional court decision. So it's a very interesting approach. And the second approach is that, like in Czech Republic, where in very exceptional cases, the court itself may decide that to give retrospective effect to the decisions of the Constitutional Court. But it should be based on some principles. First is it should be the last resort to address the violations of constitutional rights for the citizens of legal entities, for individual applicants. And second, it should not lead to the unproportionate violation of the principle, disproportionate violation of the principle of legal certainty, which is very important because there are two principles which should be balanced. This is the principle of legal certainty and the principle of redress of the human rights violations, constitutional human rights violations. So this was very brief observation of my presentation, which I believe has been distributed among participants. Thank you very much.
Щось видно, да? I thank you and organizers for giving me opportunity to share with you Croatian experience, and in order to spare time, I will move immediately to my presentation. As you could understand from my written work and general knowledge, I believe, Croatian secession from former Yugoslavia was painful, and it brought to war, which caused occupation of Croatian territories and hundreds of thousands of displaced persons and refugees. The victory and liberation of territories in 1995 brought, however, another kinds of problems, such as reconstruction of the country, return of displaced persons and refugees, and peaceful reintegration of eastern part of Croatia, which was under UN protection. In relation to that, it showed up that state many times showed legislative optimism which could not be realized. Established rights or conditions for them were many times changed or abolished. But looking back to that time, larger problem was practice of administrative bodies which many times denied the rights due to narrow or arbitrary interpretation. For that reason, I will depart slightly from my written presentation and refer here to Convalidation Act, which was not mentioned there, but it was a good example for the previous statement. The act was introduced after the war in order to legalize, actually to convalidate, all acts of the authorities which operated on previously occupied territories. The idea was actually to bring legal status of those citizens in line with Croatian legal order. The act was short and rather general. It left to administrative bodies a great margin of discretion in deciding the cases. Although the administrative court, let's say, channeled application by interpretation of some notions, nevertheless, in many cases, it failed in protection of the rights because of excessive formalism. In that regard, this act, for example, foresaw convalidation of pension rights under conditions that the relevant evidence is submitted and that the person is registered in the so-called pension fund which operated on the territory which was occupied. It showed up that many applicants were not, for some reason, registered in the pension funds, although their working status was recorded in their labor cards and the employer had the evidence on them. The administrative court regularly denied the recognition of those rights with the view that the lack of the records on their status in the fund that was operating on the occupied territories was determining fact for it, and therefore the convalidation was not possible. It meant actually that non-existence of the records in the fund were prevailing in relation to other evidence that was submitted. The Constitutional Court held that such provision did not actually liberate administrative bodies from the obligation to proceed with the General Administrative Procedure Act, by which actually they decide on the case. Namely, the court thought that this act, General Administrative Procedure Act, imposes the respect of principle of substantive truth and requires the checkup of additional proving material that could be applied in deciding the cases. So, by the opinion of the Constitutional Court, Administrative Court failed in judicial protection because it took evidence on account and against the right to fair trial. Next to it, the convalidation could not make the persons who were active members of paramilitary forces on occupied territories or who fought against Croatian forces. The case concerned the person who worked in textile industry on the occupied territories and who in his application for convalidation stated that he was mobilized in paramilitary forces. The administrative bodies immediately denied the convalidation, although the citizens claimed that he was only mobilized. The same approach confirmed the administrative court, claiming that such membership and that such notion is enough to deny the rights right to convalidation. The Constitutional Court again abolished the decision, stating that just a pure notion of being mobilized in paramilitary forces did not mean at the same time the active involvement against the creation forces, and concluded that the facts were not established fairly. Formalistic and rigid approach of the administrative court by the opinion of the Constitutional Court contravened to the essence of convalidation. I will close my speech referring to the case in my presentation related to war veterans and suspension of recognition of their status by law. I repeat that in Croatia we have this institute exceptio legalis, which is hardly used. The courts almost never use it in order to secure human rights of citizens during the proceedings before them. They apply the norms the way they are given without examining whether the given solutions might violate human rights or are illegal or unconstitutional for other reasons. At the end, I must say that decisions of the constitutional courts are largely respected. However, we have experienced several cases in which the courts repeated their opinion, and we had to abolish them again in the constitutional proceedings based on the constitutional complaint. Dear colleagues, I thank you for your attention, and please, all of you who have additional questions and cannot get the answer are free to write to me. My email is available by the organizers, and I will be happy to exchange the views on matters of your worry or your interest. Language barrier could be replaced by Google Translate. Thank you very much.
The topic of my presentation is the lawmaking nature of the judgments of the Constitutional Tribunal in Polish legal system. It is necessary to start by considering the types of judgment of the Constitutional Tribunal in the Polish legal system. First, affirmative provision article is in conformity with Article Y of the Constitution. Second, negative provision Article X is not compatible with Article Y of the Constitution. Third, interpretative provision X understood as is compatible, not compatible with Article Y of the Constitution. Limited, fourth, limited provision X to the extent that is compatible, not compatible with Article Y of the Constitution. Fifth, applicative, e.g. Article X is not compatible with Article Y of the Constitution, for instance, which does not create a basis for the refund of tax paid under this provision. It means Article X is not compatible with Article Y of the Constitution, but fees collected under provision X are not refundable. Sixth, with a deferral clause, provision X is unconstitutional and expires on day Y. Seventh, resolution. This classification is not exhaustive, as there are judgments which do not belong to any of the above categories, e.g. preventive judgments or signaling resolutions. Furthermore, neither is the classification exclusive, as some judgments belong to more than one category at a time, e.g. ostensibly limited lawmaking, ostensibly limited interpretative, negative interpretative judgments, affirmative interpretative judgments. Their diversity also becomes apparent in the different legal effects that ensue from the judgments. Some judgments have clear legal effects, although such constitute a minority. A special case here is provided hereby, above all, interpretative, limited, and in recent years, applicative judgments. From the tribunal's point of view, the normative consequences of the judgments are obvious and clear, regardless of the type of judgment in question, both with regard to classic affirmative or negative judgments, as well as to interpretative, limited, or applicative judgments. The outcome is always the same. They are of universally binding application, as the tribunal has repeatedly stressed in its judgments. On the other hand, in the literature and jurisprudence, various arguments are put forward to assert that any tribunal judgments which are not classic affirmative or negative judgments are not binding. The most frequent charge is that the tribunal is not competent to issue judgments other than such classic ones. It is particularly noteworthy that not even the Supreme Court presents a uniform position on this issue. In the discussion on the binding character of the tribunal's judgments, it is also pointed out that taking into account interpretative, limited, or applicative judgments may lead to splitting a legal regulation of a given institution into parts that are compatible and not incompatible with the Constitution, which undermines the normative construction of this regulation and may result in giving it a shape that was not intended by a legislator. For example, the Supreme Administrative Court has decided that although the constitutional tribunals do not have the general power to make a generally binding interpretation of the law, assessing the competence of the constitutional tribunal to determine the limits of its judgments is another matter. Questioning of the possibility of the constitutional tribunal to specify how the impact of its judgments is limited is unfounded. In turn, the Supreme Court stated that the Constitution does not segregate the judgments of the Constitutional Tribunal and does not impose any classification of the binding force of its judgments. The multiplicity of doctrinal divisions, however, does not make it necessary to discuss which of the tribunal's judgments have full binding force, which only partial, or which have no binding force. Constitutional norms do not allow for such selections. Such selection would be an extremely dangerous process, since it could undermine the classification made by the courts or the doctrine. However, the following conclusions are widely accepted. Each court or administrative authority is obliged to comply with the Constitutional Tribunal's judgments from the moment they enter into force, given that they are assigned universally binding force. The recognition of the substantive legitimacy of the decision and reference to it explicitly in the judgment is necessary, regardless of the nature of the tribunal judgment and its binding force. With regard to the issue of whether the judgments of the Constitutional Tribunal is in which a declaration of the unconstitutionality of a given legal provision is made have only prospective effects for the nature, i.e. ex nunc, or also being declaratory, have retroactive effects following the enactment of a provision that is incompatible with the Constitution, i.e. ex tunc. It was possible to observe divergent statements being made on the same subject by the Constitutional Court or Constitutional Tribunal itself.
Дякую. Having legislated the possibility of reviewing court rulings adopted on the basis of laws recognized unconstitutional, the state actually fulfills its commitment to restore the rights that it violated as a result of the adopted act, which was later subject to judicial review and thus recognized unconstitutional. Therefore, it is natural that a person whose case has been decided on the basis of an unconstitutional act shall have the right to expect effective judicial protection by applying for a review in exceptional circumstances. In the context of this issue, let me analyze a text-related case, which, although not being subject to the review by the Court of Cassation, was still considered by the Court of Appeal. For this case, very clearly outlines the issue. This case that I wish to present to you, the taxpayer appealed directly to the Constitutional Court with a constitutional complaint. And here we're talking about a company called Metro Cash and Carry. And the first Senate of the Constitutional Court of Ukraine ruled that the provisions of the first sentence of paragraph 26, section 1 of the law of Ukraine on amendments to the tax code of Ukraine to improve business climate in Ukraine, this was found unconstitutional and demanded to clarify certain provisions to eliminate contradictions arising since it had been adopted. Because they wanted to improve the taxation climate in Ukraine. According to this law, the accrued and paid land tax amounts during the anti-terrorist operation in accordance with Article 269 and 289 of this code for land plots located in the temporarily occupied territories and or settlements along the line of the contact and or areas of combat shall not be subject to refund to the current account of the taxpayer. They shall not be used for repayment of any tax debt or fees, shall not be returned in cash in exchange of a receipt in the absence of the taxpayer's valid bank account. Therefore, referring to the decision of the Constitutional Court of Ukraine, the said business entity complained to the court with a request to review its decision in those exceptional circumstances. At the same time, complaint was rejected with reference to the case law of the Supreme Court on the grounds that at the time of the disputed legal relations and at the time when the courts of first and appellate instances ruled that those provisions were in force and applicable. So the complaint was denied. The decision of the Constitutional Court of June 5, 2019, in the opinion of the court, cannot affect the disputed legal arrangement, as in that case, it arose from the decision which is not retroactive and affects only the legal matters that take place from the date when the decision was made. And based on this case, the decision of the Constitutional Court of Ukraine on legal acts unconstitutional provision applied by the courts, it's not a sufficient ground for revoking court decisions, because in this case, the court should apply the law, which although was declared unconstitutional, was still valid at the time of the disputed legal relationship. In general, the courts have formulated an approach that does not recognize the right to review in exceptional circumstances of court decisions on the grounds provided for in paragraph 1 of part 5 of Article 361 of the Criminal Procedure Code of Ukraine for 3 reasons. First, at the time of court decisions were made, the provision of law which was later declared unconstitutional was in force at that time. Second, the decisions were not enforceable. And third, the review of decisions on these grounds violates the principle of legal certainty, res judicata. At the same time, on February 20th, 2020, the panel of Administrative Court of Cassation within the Supreme Court decided that in view of this, there is an exclusive legal problem to be resolved by the Grand Chamber. Therefore, today we're still waiting for the decision of the Grand Chamber on the issue raised. And it also seems appropriate and meticulous analysis is necessary for the legislator on such a legislative regulation, which is currently contained in the Code of Administrative Procedure, in order to enable the implementation of administrative proceedings in the consideration by courts of applications for review of court decision in exceptional circumstances. Thank you, Ms. Maria. Thank you for your topical presentations. Thank you for the time that you have used and for getting across your idea.
So here to my colleague, Mr. Kravchuk, who will demonstrate the way to argue in favor of application of this retroactivity. Thank you very much. Good afternoon, everybody. I will try to use a presentation and please show me whether you can see it. Tell me whether you can see it. So yes, I apologize. 10 minutes, please. All right, 10 minutes. So I'm part of this panel that expressed doubts concerning the fairness of the aforementioned approach. That's why let me draw attention to the doubts that were of our concern. In fact, what the question is why should a law be declared unconstitutional? What would be the effects? As for me, non-constitutionality should be viewed from the point of view of the Constitution. The Constitution just we can say the Parliament, by passing the law, violated the Constitution. So this is the violation from the very beginning. Still in the body of the law that will be declared unconstitutional later on by the Constitutional Court. The Constitution of Ukraine clearly declares the responsibility of the state before an individual for their activities. And if an individual was subject to application of non-constitutional law, this individual should be entitled to compensation. That's what Articles 56 of the Constitution reads. In addition, this approach of liability of the state for any damages caused as the result of adoption of legal legislative act, which later was declared illegal or unlawful. This compensation is also provided by the Civil Code. So we can see here a very clear mechanism. First, the state is responsible and liable. Second, it's liable for any damages caused by unlawful act or deed. And then there should be a procedure or kind of proceedings through which this constitutional institution can be implemented. This is the general law, a general approach applicable to all individuals who actually fell under the scope of this act and suffered damages. But among all these individuals, one could separate a small group of individuals who filed claims with the court right after the non-constitutional law, as they believe, allegedly non-constitutional law that was applied, they immediately addressed the court. But before that, they had to go through all available remedies before, exhaustive remedies, and then they apply with the Constitutional Court, and let's say that was individual claim that where they win. Let's call them claimants. These people would have special status. So we talked about general algorithm of compensation of damages. For these claimants, a special procedure, in particular, this is Code of Administrative Justice, will apply. We can also mention other codes of procedure because all of them contain similar provisions. So for these individuals, who have been subject to some judicial proceeding, there is a special institution, the Institution for Revision of Cases due to exceptional circumstances. I need to tell you this is not typical for European countries. At least I didn't find anything in the respective European countries' legislation. I couldn't find this institutional exceptional circumstances. But let me draw attention of our international experts that in Ukrainian legislation we used to have the institute, the newly established circumstances, but then a separate body of exceptional circumstances was defined. It's not only about the violation of constitution, but also about judgments of European Court of Human Rights, which found that the convention was violated. So, exceptional circumstances are both decisions on non-constitutionality and decisions on violation of the convention. They have the same force according to Ukrainian legislation, and the goal here is to correct the mistake. I need to say that any judicial revision under these circumstances certainly is in violation of res judicata principle, but same applies to the constitutional judgments because it's about a revision of any judgments that have already taken effect. So we need to look for another argument. This is the argument of values, because correction of errors and mistakes is not only about correcting the situation of an individual claimant. The correction of errors is a tool to improve the overall fairness of justice, because one should not probably assume that the courts are well aware of their errors, but they do nothing in order to correct these errors. That does not mean the notion of fairness. And actually, the system that is capable of correcting the errors is an institute of public interest, because all parties are always interested in correcting the error committed in their case. Public interest is what? These are general interests. There are 30 of us here, and 20 of us can say that they wish something, then the sum of our interests would depict our general common interest, which means the public interest. So, actual exception from res judicata is not something untouchable. But, it's about removing an error, correcting an error committed by the state with regard to an individual. This error certainly needs to be corrected, because the simplest formal argument that can be made here consists in the fact that in this way, because otherwise the principle of responsibility of the state to citizens, according to Article 3 of the Constitution, will not be implemented. So, in this way, the main values of the Constitution would be violated, while in the law hierarchy, certainly values are higher than principles. I mean, that interpretation of any law should not generate result which is incompatible with the values protected by the Constitution. Grounds for revision indeed are worded in a quite confusing way, because judgments that can be reviewed based on their constitutionality are those that have not been executed yet. This is what the Administrative Court of Justice reads, which means that there is a judgment, it's subject to execution, but it has not been executed yet. I think it's a very narrow interpretation. I think that all judgments, whether subject to execution or not, no matter whether they have been executed, should be subject to revision if there are doubts about their constitutionality. Defending this opinion, we approach the situation from two sides. It's not only about constitutionality of a deed, but also about constitutionality of a law. Imagine that a court starts with the presumption that, say, a local court decided to address the constitutional court because of having doubts about constitutionality of the law. Imagine that the constitutional court, upon consideration of this case, holds that, well, this is quite constitutional. In the meantime, during this period of time, this say local court was not applying this provision. So, this is what we argue, that actually if a provision is declared constitutional, it should not then, the judgment should not be then revised. Let's say we had seen judges were trying to improve their remuneration. Mr. Larson mentioned several situations with that company. So the court did not apply provisions of the law that later on was declared constitutional. The civil servant was entitled to payment, and if the payments were made, then the judgment, the decision, it has been executed. But in this case, you see, if in our situation it has not been executed, then it will not be executed in the future. So we just forget that here we are discussing both constitutionality and unconstitutionality of a provision. So what we believe is that all judgments should be subject to revision under exceptional circumstances if they were based on the law that generates some doubts. Well, there are some categories of cases where there is no execution at all, where execution is not possible, but the cases where certain condition is just stated. They are cases about lustration or dismissal of a judge who failed to pass qualification evaluation. What happens if the Constitutional Court declares the qualification evaluation unconstitutional? Then, even those judges who lost this case, should not they be entitled to demand another consideration of their case? I think if you apply the situation to yourselves, I think you would understand. I call this test, I conducted among my colleagues, I call it the skin test. Say, if I take myself under the same circumstances, I probably would not believe that the approach was fair if my request for justice has been denied. So certainly this fails to meet the very spirit of the Constitution, the spirit of the justice, which should be fair by definition. This is what we are responsible for, to ensure fairness and justice to the society. Another purpose is to provide for effective protection of the rights. So when we talk about restoration of individuals' rights, we need to look for the fastest and most efficient mechanism to defend an individual. So, to sum up, to make some conclusions, I would say that we believe that only through recognition of the right for review and the exceptional circumstances, which include unconstitutionality of the law, is the only way for us to ensure proper protection of the individuals and the effectiveness, the real effect of constitutional compliance. Because even if we do not allow for judicial revision of a previous judgment based on results of consideration of constitutional complaint, that just would not really mean anything, not only to the individual, as Mr. Halavati said, but it would be the failure to defend an abstract value of a law. And actually, we already mentioned that actually the judicial system is aimed at ensuring lawfulness and protection of individuals. So I suggest having more practical, pragmatic approach to these issues, and we need to recognize that our laws are quite progressive, no matter what happens in the Western countries, because our laws allow for constitutional complaint, for revision based on exceptional circumstances. We just need to give to it proper interpretation as lawyers. We do not need new legislation. What we need to change is our approach, our legal conscience. And I think that the way I suggest interpreting this provision is for the benefit, for the good of the people. Natalia mentioned that now it's under review of Grand Chamber. I'll tell you that the Grand Chamber didn't find any major problem, and now the case was referred to the Joint Chamber of the Constitutional Court, where it will be reviewed and considered again. Thank you very much. Thank you for a very clear point for your vision of the mechanism that you just suggested. Now I'd like to refer to our analysts, and I'd like to invite all to see a presentation prepared by Mr. Broker, where he conducted a serious analysis of the Code of Administrative Justice and comparing to the German legislation. Please, the floor is yours. I became familiar with the Ukrainian system last year, and actually, our team indeed implemented some principles that may seem contradictory. It's about legal certainty and the fairness. Well, I will take kind of a German look to it. So I try to approach it in this presentation. It's a bit difficult because we are trying to use our tools. It's about what I need to say, that in principle, indeed, we have very similar structures in Germany and Ukraine. I think Mr. Smokovich, yes, mentioned that, and we often tend to believe that it's better we work together. So actually, there is a need to somehow balance this issue, this is a matter of how a judgment can be cancelled or revised. Let's say if a constitutional court declared it unconstitutional, but that's one aspect. And another aspect is about whether the judgment has been executed or not. Actually, this is what actually this judgment may be executed or not. So if I take, say, I filed a claim for the administrative court, then I lost, and then I addressed the issue to a constitutional court. So actually, it's not cancelled, but it might be subject to review. When the situation, let's say, there was a building that was subject to demolition and it was prohibited. But another point is where the building has already been demolished, and it's there where you could say claim for compensation or anything like that. It's about cancellation of a judgment that has not taken effect yet. It's talking about the trial courts. So another issue is about cancellation of a judgment delivered by a court of appeals. And so it's if we think about other aspects, there is a need to ensure substantive fairness. It's quite well difficult to imagine. Let's say a constitutional court made a mistake in return. Okay. Let's assume they recognize it non-constitutional. It does not mean that any previous similar judgments delivered by, let's say, trial court were not admissible either. You talked here about the public interest or public benefit. It's always something talking about the representative democracies where we have parliament, but you need to defend your opinion and requirements. Let me give you a very simple example. Let's take a government. Say the government makes a decision to support children or school or whatever so that they can go to schools, and let's say there should be a bus to bring the children to school, etc. But that will work only for public schools. Maybe any private schools or the church schools would not be entitled for this support. So the parents who sent their children to a church school then respectively file a claim, a complaint. Well, they refer to discrimination and things like that. And say that they go to final instance. Well, here, yeah, one would conclude that that's a fact of discrimination. There are private schools and they should be the same as, have the same rights as public schools. So in German situation, let's say if a law has been declared unconstitutional, nobody will receive anything. And if a law is then non-constitutional, certainly there will be but there is an advantage which is not so difficult. Actually, the court cannot replace legislators, so possible option is that no one will benefit from this decision. Say the government will say that we have no money for that. So it's hard. You see, it's really difficult to imagine any automatic consequences upon similar judgments of Constitutional Court. Well, which means citizens are supposed to take initiative and to file complaints by themselves. I mean, once any provision is approved, what would the consequences be? Well, there are different opportunities. Is everyone aware of opportunities? So now, anyway, under such circumstances, Constitutional Court will become a central player. Thank you very much, Mr. Director. I'd like to say that we will continue our discussion with our panelists, but I'd like to take this opportunity in order to ask an important question that we've already had several times.
From your report, it seems that if a person doesn't require any pecuniary or non-pecuniary damage to be compensated, doesn't it look like some kind of a preventive means of protection? Because we have this point of view that in this way, the Constitutional Court exercises more a preventive role, a preventive effect for the future. For example, to make sure that the legislator will correct himself in the future or will take correct decisions or the correct legislation. But here, in connection with this, arises the second part of the question. Today, we have heard from Mr. Kravchuk, and we also saw it in our materials, and we will see it further on today, that we have to correct the state committed by the mistake. And in your presentation, you said that we cannot interfere with the activities of the legislator in this conjunction, because it's clear and obvious that at a certain point, legal relations appear and legislator legislates, makes laws, and this is his or her direct mandate, main authority. The legislator goes through all of the stages in order to adopt these legal normative acts, should consider the purpose for taking this action, takes into account economic consequences of enforcing this or that legal act. And in line with this, can you please tell me, did we understand you correctly that here there is a certain line, certain limit, and when we recognize a law or an act unconstitutional, we cannot perceive it only as a mistake of the state, because on the other hand, it can also be assessed as an interference with the legislative branch of power, because sometimes 2-10 years pass on, the society moves on, things get changed, relationships change, structures of payroll change, and understandably, because of objective reasons, even if there were 1,000 legislators will not be able to come to speed with all of the challenges that we have in the contemporary society. Thank you.
First, it's a question about preventive aspect, number of different aspects in this question. So we need to keep that in mind. There should be aspect of individual protection, and also there is an issue about defending the general legal order. Well, and certainly there are two effects about it. If we have, say, constitutional court and it has large, wide competences and a citizen may easily have access to this court. So the parliament will be aware that there is a controlling or a checking checking institution that certainly would have probably positive effect for parliamentary initiatives. And the same applies to the government concerning their requests that they suggest or suggestions that they offer to the parliament at the country. Weimar's Republic, yes, those times. And my colleague from Austria also mentioned that. So it's maybe positive impact for legislators. So in my examples, I meant something different. Constitutional court does not say cancel a law because just by mere cancellation, nobody gets any benefits. In Germany, I'd say that the form of it may be stated that the form of the law is not constitutional, then the law is invalid. But the effect of this law will continue, let's say, for 2 more years. And within that period of time, the legislators are supposed to find new regulation. That means the ball then goes to the legislators' field. So here is an example that judgments delivered by Constitutional Court is requires special techniques, some procedure. The actual Constitutional Court would not always interfere into the competencies of the government. So actually, as far as further procedures are concerned, all this under the condition that the legislator will obey, will follow the judgments of a constitutional court. If the Constitutional Court doubts whether the judgment will be implemented by the legislators, then the decisions Even there are practices when, say, the judgment has not been implemented in 2 or 3 years, that the judgment is cancelled. So this is kind of a reservation that existed, provided that the legislators comply. And the third point is about compensation of damages. Again, that actually you can file claims for damages to the government or to the state. So these are absolute exceptions when, say some unlawful situation emerged because of mistakes by the parliament. More often that happens because of actions of the government executive rather than parliament.
Thank you, Mr. Broker. Thank you for your presentation, for the time that you are staying with us. Now, colleagues, we have heard a number of positions. Also the position by Mr. Holovati. From the very beginning of our today's seminar, he provoked us and made it even more relevant to our discussion. We've also seen the position of Mr. Volodymyr Kravchuk, who focused more on the Code of Administrative Proceedings, and he gave us a very clear-cut position of his own, how he sees this mechanism can be further improved. And now with the view of looking for this mechanism, restoration of rights, in this special session, we keep moving ahead and we keep looking for the answers to the questions posed. Moreover, Mr. Broker has just given to us certain explanations concerning the practice and the legislation that in his country courts are shaping. And we have also seen very clear-cut specificity of this mechanism, how it interacts with the Constitutional Court, with the Administrative Court, and with other authorities. We see this very clear connection. And from this perspective, I would like to hear from Ms. Slavica Vanic. I can see you wanting to make a comment. You're welcome.
I just wish to tell you that in Croatia, the situation is slightly different. First of all, we have full constitutional complaint. We do not have normative complaint. But we have a kind of, actio popularis initiation of the constitutional procedure on examination of a constitutionality. So in that regard, we have the situation actually, everybody who proposes to the Constitutional Court the examination of the constitutionality of a certain norm or a law, and if it happens that the Constitutional Court establishes the violation either of the principle of human right, the person who proposed the proceedings before the Constitutional Court has the right to initiate actually the renewal of the procedure in order to obtain another individual act which is not based on the unconstitutional norm. In the case that the judgment is executed and that the legal consequences have appeared of that individual act, the person in Croatia has the right to ask for the compensation of damages in the procedure before the ordinary court. So this can be filed within 6 months from the decision of the Constitutional Court. So it means, that we have a little bit different situation. We have already set situation in our Constitutional Act. However, I wish to tell you that the Constitutional Court during my mandate was very active. And we had the situation when actually the legislator introduced the public executors, those, who actually execute the the debts and everything else. it happened that the new government actually proposed abolishment of this law. So the people actually who were educated in order to be public executors found themselves in a very difficult situation, you know, that they lost their jobs, previous jobs, and suddenly they actually stayed without new job. And the Constitutional Court actually, by abolishing the situation that was given by the legislator, actually installed the right to these peoples who were affected by this law, the right to be compensated in the regular procedure. And I believe that there are still cases pending in that regard. Thank you.
Thank you, Mrs. Slavica. Thank you for your practical experience, which I understand has already taken place in our country also as an exception. At this point, I would like to ask our technical moderator to put on the screen certain quotations, just like it was in the first session today, from the people that express their opinions and regards in their written works. And because we have changed the format of our today's event, they couldn't come and be physically present today. So Albert Piezero, he's the judge of the Administrative Cassation Court within the Supreme Court, and he is an associate professor. So he says the institution of judgment revision, first of all, is aimed at the correction of the errors made by the state. In case the rivalry between the correct and the stable, preference should be given to the first. And the judgment, even one that has already been enforceable, may be reviewed upon the application of a party or another interested person if the court decided already on their interests, reasons, interests, or obligations. Now, please, next slide. Dmytro Terletsky, head of the Department of Constitutional Law, National University Odessa Law Academy, PhD in law, associate professor, assistant professor. In particular, he said, agreed amendments regarding the effect in time of acts of the Constitutional Court of Ukraine must be introduced to the Constitution of Ukraine, the law of Ukraine on the Constitutional Court of Ukraine, as a whole, and in general as a whole and in part, through a procedural legislation. And in our events, such amendments should be unambiguously enshrined in exceptional cases. The application of the ex tunc temporal principle for the judgments of the Constitutional Court, which ensures the constitutionality of legal acts of the highest public authorities and makes sure that there is a balance between public and private interest in place. Thank you. So we have already heard similar opinions and thoughts expressed by our colleagues and panelists at international level. Likewise, everybody is giving them a thought, and every democratic country which targets the protection of human rights definitely is interested in finding a solution to this issue. Now I would like to invite Mr. Paposhvili to join in our discussion. And I have an interesting question to ask him. Mr. Paposhvili, in the first session, we heard a very interesting position expressed, very clear concerning the constitutional complaint. Mr. Holovaty expressed it, and in line with that, I have a question to ask you. I did not complain, Miroslava. It wasn't my complaint. I said that you were talking about the constitutional complaint. You did not complain yourself. I'm sorry, you wanted to joke, but it's beyond jokes. Please turn off your microphone with all due respect. And in line with this, I have a question to ask you, Mr. Paposhvili. Do you really have in Georgia, but please be brief, do you really have various forms of exercising constitutional oversight by the Constitutional Court? As well as that, if you have different forms in place, I mean, if you have the constitutional complaint, And you can exercise constitutional oversight, constitutional control, as we call it, to see if laws or normative and legal acts comply with constitutionality, if there is a certain application or submission by various authorized bodies. So in line with this, I would like you to also tell us, as far as I know, the legal nature of the acts of the Constitutional Court is virtually the same across the world. So all of them have universally binding nature, especially if we talk about a certain nation where this decision was passed. So do you think this will be some kind of injustice or unfairness in place if we compensate people only because of the constitutional complaint, and at the same time will not be responding to the facts of injustice because the norm in a certain case was also violated when a judgment was passed, and later on the Constitutional Court found this norm to be unconstitutional. Thank you.
Thank you. First of all, let me greet all of you, all the participants, and first of all, Slavica Banic and Sergei Holovatov, with whom I worked in Venice Commission in other occasions. And second, I want to mention that the topic is very sensitive and very important, and so congratulations to organizers, because the topic is exactly very practical and theoretical also, and it seems there are a lot of debates, and there is no precise recipe for this, and there is no solution, it seems. Nobody can teach now, nobody, especially in countries in transition, because we have different problems now. In America, in US, they may argue between each other whether activist judges are better or conservative judges, self-restraint is better or activism is better. In our countries, the problem is whether we have unbiased judges and qualified judges, and whether the judiciary is independent or not. But this type of discussions promote, of course, the qualification and the practice of the judiciary. It's also important that you asked both ordinary court judges and constitutional court judges, because in many times they work independently and they go in different directions, and both interpret the law. Constitutional judges interpret constitutionality, but ordinary court judges or justices interpret legality. But in the same sense, the wording could be different. And for consumers, for citizens, or for legal persons, sometimes it's a bit confusing when the two judges go into two different directions. In US, it's easier because this is just one institution which is responsible for judicial review. It's ordinary court, but in most European countries, we have separate constitutional tribunals or courts, except some Scandinavian countries and Estonia maybe. But I missed the first question, maybe because of translation, but maybe I start with the second question. Because in Georgia, I don't hear them.
Would you like the first question to be repeated to you, right?
Yes.
I got distracted, I'm sorry. Do you, concerning the form of judicial oversight or control, the Constitutional Court in Georgia, does it exercise its oversight in different formats? Because you have a constitutional complaint in place, and you have also judiciary reviews when people apply various, file different applications when they want to see whether an act or a law can be found unconstitutional. Well, according to our legislation, this submission has to be made by no less than 45 parliamentarians or ombudsmen or the candidate of ministers. So how does it happen in Georgia, please?
So yeah, now I understand. So to be brief, because other also participants probably want to express themselves. So in Georgia, the 95% of applicants are individual applications, and just parliamentarians are a bit lazy because its timing is long. So for political reasons, it doesn't make for them the sense to apply to the court and wait for 1 or 2 years when they have political agenda very quick, you know, not just Georgians, but probably in Ukraine also. They are very emotional people, politicians. So mostly these are NGOs and individual complainers, and public defender ombudsman office also. He or she has the right to apply, so mostly they apply. But the point is that I mentioned in my presentation about the case which is still pending before the court, and for which Venice Commission provided in 2018 amicus curiae. Maybe Sergio or Slavica, they knew, maybe they were present at that time. But Venice Commission did not give a precise answer because the question is still very delicate. And in this case, Venice Commission gives you have option 1, 2, 3, and then it depends on the country. So the question was exactly what discussed today, that this complainant, TV owner, they applied whether but it was about the civil legislation, which is the most difficult part. In administrative criminal cases, so more or less it's clear. In all countries, it's the basis for reopening the case or to have a retroactive effect. But in administrative cases, it's much more room because it's still a vertical approach because it's a state and the citizen or legal entity. But in civil cases, it's most difficult part because there are civil parties which are equal and which have a consensual basis, the agreement. So how to interfere in these cases? Unfortunately, the Georgian Constitutional Court, it's already 4 years almost, could not give an answer to that. One of the issues is that because the complainant lost the case already in ordinary court, and so they lost their interest now to push the Constitutional Court, give us the answer quickly. And the court is still thinking, although when I was in the court, there was a draft and I could not reveal secret information, but I could say for myself that my approach was the same as, not the same, but my approach was that in some cases, exceptional cases, when there is no other option, it could be possible that in civil cases also the Constitutional Court could impose sometimes some kind of retrospective effect to its decisions, when especially like in Georgia, in many other countries, there is no clear-cut provisions and wordings in the constitutions and legislations. If in Ukraine legislation constitution there is very clear wording, of course there would be no debate, like in many other countries, because not everything could be predicted by legislators. So it would be good also if they are present also for the future, maybe they also try to modify the legislation according to the practice provided by the justices and judges of constitutional ordinary courts. This case showed that Georgian judges are before a serious dilemma, and I put that in
in Georgia, do you have the practice of compensation in place? How frequently, how often do people get compensated pecuniary because an act or a law or a provision in the law is recognized unconstitutional, especially based on the constitutional complaint? Thank you.
Yes, it's a very rare case. Theoretically, it's possible, but in practice, there were 2 or 3 cases just. Because, to imagine in practice how it works, you should apply to the Constitutional Court. In 2 years or in 1 year or 3 years, depend. You get answer, positive for you, theoretically. Then you go to ordinary court. Then in ordinary court, you wait for 2 or 3 years more and something like this. If you don't have, resources and lawyers or NGOs supporting in this case, it's very difficult for ordinary person to find a remedy for that. So, theoretically it's possible, but in practice, I remember just 2 or 3 cases. But it was not dramatic financially that, it was not a big burden for the budget, but it was a good example that it works.
Thank you.
I missed the second question, or?
I'd like to now request Natalia to participate. I'd like to discuss with you some unfair situations that may occur because of the legislative provisions of administrative code, constitution, even legislation. Do you see any ways to restore this fairness, this justice? Would it be possible to do it within the framework of our Code of Administrative Justice? Thank you, Miroslava. Thank you, first of all, for this very interesting event. I'm also thankful for the opportunity to address all participants. As I mentioned in my video, and today actually Vladimir Mikhailovich repeated this, the problem is not always in the wording of the law. It's quite often with the interpretation. And actually the problem that is now under review of the joint chamber, we cannot predict the results, but I'm confident that we can indeed improve essentially the situation of the individual who have already received judgment based on their constitutional complaint by just changing our approaches. Another point that has already been discussed, Vladimir Mikhailovich mentioned that this constitutional complaint should not be just about correction of a mistake. It should produce some practical outcomes. And I would say that as of today, from the very implementation of the Code of Administrative Justice, this point of filing a complaint with the Constitutional Court, it is possible only after the judgment by the Administrative Court has been delivered. And we consider this provision certainly is unconstitutional. We probably need to revise this paradigm, and I think that's a good matter for further discussions. And now we just cannot really expect any benefits for an individual who applies with the code. Now we are considering some amendments to the Code of Administrative Justice with regard to, say, subject matter of claims or complaints. But the question is whether an individual needs to request that unconstitutional laws should not apply in this individual situation. So probably we need to revise approach to this paradigm of interpretation regarding the concept of execution and application of this provision based on exceptional circumstances. Mr. Holovat, you have a floor now. Natalia, thank you very much for your position. I fully support your opinion that we, as a power, branch of power, as courts, can do many things at our own initiative instead of waiting for legislators to do something, including the area of individual legal relationships. So I'm very supportive for you. Mr. Holovat, can you say it a bit later? No, just now, please. Just exactly along this line. The point that in 4 minutes you will conclude. No. And the question that you asked to esteemed Justice Blazhivska, I'd like to hear, as part of conclusion, a practical advice to me as a justice of Constitutional Court concerning what should I further do. I have a lot of constitutional individual complaints. What should I do? Should I consider them or should I stop? Why? Waiting for legislators to amend the legislation and to define whether there should be any ex tunc effects for claimants. I wouldn't expect that from them, that at least that will happen soon. Another point that once we have a judgment of your court, and based on judgments of constitutional court, in abstract, like for instance, your court has already held that actually our judgments do not have retrospective effect. But that, as far as an abstract is concerned, what about individual complaints? And Justice Bozhivska mentioned that they intend to change the practical approaches. So should I really expect an opportunity not to postpone the individual claims just because I will be able to see any prospects potential for their retroactive application, because actually Ukrainian legislation allows for revision based on exceptional circumstances. So your advice, what should I do as a justice of constitutional court who has a docket of individual complaints? Well, thank you. That's a specific question to Natalia. No, that's a matter of principle. That's the key problem. What should we do? I mean, constitutional justices, should we just continue our theoretical research in abstract? Should we forget about specifics of a constitutional complaint because there is a special judgment of our court stating that that's for the future? Or could we expect that you will change your approach and then we will not need to work just theoretically anymore, but we'll have opportunities to provide effective protection to an individual whose rights have been violated because of unconstitutionality of a specific provision, not the law in general. So maybe Natalia would like to say something, and then I'll offer the floor to Mr. Broker, of course. Well, I had this message by Mr. Holovati. That's exactly now the point where we need to change the paradigm. We're just waiting for judgment of joint grand chamber because they have authority to change their approaches. And I will just add another detail here. Say, Mr. Holovati, in addition to individual complaints, you have complaints filed by ombudsman, and of course, the subject matter of this conference is very relevant. We have a law according to which there should be compensation for failure to compensate some taxes. And actually, this law is expected to take effect on 21st January next year. I mean, the specific provision of this law. So, the law will take effect next year. There is no judgment delivered by Constitutional Court with this respect. So there will be no way to really implement these provisions. So I think the judgments by Constitutional Courts delivered on time will certainly help restoring the trust to the judicial power. Thank you, Natalia. Yes, but I cannot help but I need to invite Mr. Lars Broker to speak. You raised your hand, please, your reaction. Thank you. I also will be very brief. I don't really want to interfere, but I'd like to say that what Mr. Holovati said should be taken in the context because that means that it kind of sounds like the Constitutional Court could not really implement the human rights properly. So I remember we had our discussion, and let me put it this way, where at that time we discussed matter of complaints filed against specific legislation, not any judgments. So I think this is the point where we have so this is so it's about complaints filed against specific judgments of the courts. Here we just need to comply with the principles. We have some principles in my country related to execution of constitutional code, but as I said, we have also federal administrative courts and you know, sometimes there are even conflicts, and if you actually get to an individual concepts or with regard to this approach to complaints against judgments, probably this approach should be really considered very thoughtfully. Now we have this chamber of the court which may decide on these issues, and I want to wish you success because, you know, there still is kind of a disbalance, I would say. Thank you. Before we go ahead with questions, polling, I'd like to refer to Ms. Banic. In the materials I saw that you kind of share some concerns or reservations about the situation that if retroactive judgments are delivered, especially in the area of social disputes, the courts then will have to decide on financial side, meaning that such judgments may lead to some additional load on the budget. Could you share your approaches and how you solve, how you decide these painful issues? Because social benefits is probably now the hottest subject matter for our citizens, pensions and salaries. What are you guided by when you decide whether this retroactivity should apply or not? Thank you.
Well, I will tell you, there was a big case in Croatia back in the 90s when the retired people actually, by the decrees of government, lost their parts for the retirement increase. And the Constitutional Court actually received these proposals for the review of constitutionality, but held it in the letter. And what happened after several years, the Constitutional Court brought actually the decision saying that these decrees of the government were unconstitutional. However, as in most of the countries, and we heard it today, the decision of the Constitutional Court have the consequence ex nunc, so they were abolished from today in the future. However, the Constitutional Court actually in its decision installed the right for pecuniary compensation for the retired people. And all of this actually caused for about, I would say, around 10 years grievance in Croatia, because we got even the party of retired people who claimed and asked actually from the state to conduct, to implement the decision of the Constitutional Court. So it was the retroactive decision in a way because it installed the right to compensation. And the government introduced about like 2 or 3 laws trying actually to balance these lost rights. And the last law in that regard was in 2005, which actually was entitled as the law which compensates the rights of retired people from 90s. It took a lot of money to the country, first of all, but that was not such a problem. The problem was actually who could obtain the right to compensation. Because meanwhile, many people, retired people died, whether this right was inherited and so on. So in that regard, it is very difficult, you know, for the Constitutional Court to actually install in a kind of indirect way retroactivity. So that's why I'm very much concerned in relation to social rights, whether they could be retroactive, because social rights are mainly the legal rights. They are not constitutional rights. So they many times depend actually of the state, of the position of the state and abilities of the state. So the right to compensation, you know, on the basis of the Constitutional Court's decision is an issue with which Constitutional Court of Croatia struggles as well. And we did not find the right solution, and I don't think that we have succeeded to balance these two issues, either to have a renewal of the case or to have the compensation of certain of the violation of human rights.
Ms. Banish, thank you very much for your view and for sharing with us your views and for sharing with us so important example concerning retroactivity with regard to the social concepts. Well, getting to conclusions, I need to recognize indeed we have failed to examine many other issues related or linked to these provisions of the Code of Administrative Justice related to decisions and judgments delivered by application of an individual, because there are some discrepancies even in the legislation, let's say, what should be the admissible delay, say, let's say, if the judgment is not implemented for 10 years, then what should be done? But since we are behind the schedule, I don't want to be very scholastic, as Mr. Holovati says. I would like to invite participants. We heard replies from Lars Broker, who gave very practical advice about what Mr. Holovati should do when he has to deal with delicate, sensitive issues, and I think this vision will help us. So, in this understanding, What should our administrative courts do? If I may, I will start from Georgi Popashvili.
So, again, so you want now the precise solution for the specific Ukrainian case, it seems. It's very expensive now to give an answer. It's a joke, of course. But I hope that these discussions will open, you know, more discussions within the courts and within the judges. It's an ongoing process, and it will be still helpful. But to take into account the Ukrainian case, we need to confess that, as Mr. Holovati mentioned, we don't have much traditions and precedents to follow something. So it means that you are the first generation of judges who will set the precedents for the future generation of judges, and they should follow probably your approach. So you are at a historical, let's say, period that you may set very important principles, judicial principles, which are not defined in details in the constitution and in the legislation. So at this point, I will refrain for exact recommendations at this point.
Thank you for your tolerant answer. We understand that there are no universal recipes. That's why let's be guided by your experience and the principles which you are guided by when resolving similar issues. For us, your experience is really helpful. Thank you very much. Now, Mrs. Slavica Banic, if you please, what do you think? What advice can you give to us, or maybe your comment, your insight concerning the question that Mr. Holovati asked? How shall we act regarding the constitutional complaint? If, let's say, an individual applied a constitutional complaint and the act was recognized as unconstitutional, and there is no proper effect in place, and at the same time, what should be done if we have a judgment passed by the Supreme Court, and in a way it can even combine and involve the Constitutional Court in the resolution provided to the case about the constitutional complaint? Thank you.
Well, honestly, you know, I was really reading carefully all of this, and I was kind of confused because I don't know whether these exceptional circumstances refer to the constitutional complaint you have in the in your system, or it refers to all cases. Because if it refers to the constitutional complaint you have and the person applied to the Constitutional Court, it had to exhaust all all remedies. In that regard, I do not see the problem. I see only the problem if there is a case of the abstract control which affects the judgment, which is already res judicata. In that case, you know, I would really go to the grammatical interpretation which you have in the Article 362.5 paragraph 1, which clearly says, you know, that the reviewing of the judgment is possible only if the judgment has not been executed yet. So, by my opinion, if the constitutional complaint has succeeded with abolishment of the provision, then you do not have the problem. But if you have the abstract control which affects already existing judgment, the application of this norm could be only in the case if the judgment has not been executed yet. I don't know whether I understood well this issue with exceptional circumstances.
Yes, Ms. Banic, you have understood it perfectly correct, because we are confronted with the same question all the time. When we talk about the subject of revision within the framework of this chapter, this article 361 that you have quoted. And you have correctly observed, because I understand you have been acquainted with the materials that we have previously sent to you about unconstitutionality. And it doesn't mention there only the constitutional complaint as the grounds for the revision of judgments.
Exactly, exactly.
Mm-hmm. Thank you very much indeed. Now, Ms. Natalia Blazhievska, would you also like to provide your insights or your comments in answer to Mr. Holobaty's question? Are you ready to provide your comments? Ms. Blazhievska, are you with us? She has disconnected from us. Okay, now I would like to ask Mr. Volodymyr Kravchuk. Is he with us now online? Once again, good afternoon. Well, sorry once again for wanting to get you speaking, but you are today the keynote speaker, the head speaker, if you like. That's why we would like to hear from you your comment concerning the question asked previously and the concern that Mr. Holobaty is experiencing right now, because he's a justice of the Constitutional Court after all. You know, talking about the practical aspect of this question, I know that at least here with us, we have one of the judges of the combined chamber who pretty soon will have to render a decision on this issue. That's why I believe and I'm confident that all of the justices in the combined chamber really take the complexity of this issue to their heart. It's truly one of the most fundamental problems, because on the one hand, we have the Supreme Court, on the other hand, we have the Constitutional Court, on the third hand, we have people who are hopeful that the instruments and remedies that they are provided with will have practical application. These are not just empty promises and paying lip service when they say, we will help you, but they don't help us because the court cannot identify or determine how this particular law should be applied. Still, in the light of the analysis and the experience of our international experts who spoke today, it seems to me that we probably should speak about the evolution mechanism for judgment review, especially if we talk about them in the light of exceptional circumstances. Maybe this will be better for the future conferences, and I'm already thinking that we probably have to distinguish between private relations and public legal relations, administrative proceedings and commercial proceedings. So when we speak about civil, commercial, and the norms that regulate private relations, here the principle of res judicata has to have a greater prevalence, because this is a private relationship type, and interference with them will specifically touch upon very specific points, and we cannot speak very generally here. But when we talk about administrative justice, that is the relationship between the state and people, here the constitutional provisions and Article 3 and the concept of the rule of law, this is all to do with the public relationships, and the convention does not ensure or protect human rights, except maybe some principal norms. Because in the convention was meant to protect people from the arbitrariness of the state. So when there are state-committed mistakes, public authorities committed these mistakes. So against everything promised, I don't know how it happens in your countries, but for me, it's a real dissonance. It's not the way I feel law to work and function. I don't feel it's just or fair. So talking about it from the evolutionary standpoint, I understand at the future stages, I would propose to focus more on this aspect, that private and public relationships, they are different, and we have to diversify our approaches, especially when we review judgments in the light of exceptional circumstances because of the nature of these legal relations. Thank you for your attention. You really inspired me today. I sincerely thank you. And I have also seen Mr. Broker's reaction from the video or to the video. Maybe I was mistaken. Maybe he was willing to provide his comment or response. No, after all that he has said. Okay. Then Mr. Mikhailo Smukovich, the president of our court, would you like to provide your comment? Because we are wrapping up our second session. The floor is yours. As a judge of the combined chamber, I will refrain from the discussion at this point, so as not to express the thoughts ahead of time before we render the decision. At one point, I spoke ahead of time, and then unfortunately it became the reason to introduce a proceeding, a criminal proceeding. I found myself in a very complicated situation. That's why at this point I would like to refrain from giving a specific answer. And let's wait for the combined chamber to express and render its judgment. But in the final word, I will give my comments, but based on some other aspects related to this issue. Thank you very much. Dear colleagues, we have to wrap up and to summarize our day. So let us focus again on our audience who have been so patient in following us today. We would like you to get active again. Please go online and respond to the survey in the questions that we formulated for session 2. Let me repeat that again. In your opinion, the most effective way to restore human rights following the application of an unconstitutional act is to 1, review the decision on the basis of exceptional circumstances, 2, compensate the claimant through pecuniary and non-pecuniary damages, or 3, do nothing. Please vote. Now we see that it's best to review the decision on the basis of exceptional circumstances. This was chosen by 71% of our audience. Compensating the claimant through pecuniary and non-pecuniary damages was the choice of 29% of our audience, and doing nothing, 0 people chose that. So we definitely have seen some dynamics in comparison to the results of the beginning of our session and as it is now, but people believe that the judiciary authorities have to respond in some way to the injustice and unfairness in relation to individuals or persons that became evident as a result of applying an act which later on was recognized as unconstitutional by the court. Dear participants of session 2, dear colleagues, dear audience, let us wrap up making general thesis about what we have heard today. Once again, we haven't heard much about chapter 3, section 3, but at the same time, I'm really thankful for the experiences that we have heard from the practical standpoint. And clearly there are still questions, and in our code of criminal justice, in the text of it, still a lot of problems remain. At the same time, we see that the problems are not only in the code, even in the Constitution of Ukraine, we sometimes can see vague points. But we understand that the constitutional complaint, if it is enshrined in the Constitution, it provides for the compensation for individuals of pecuniary and non-pecuniary damages inflicted on them. And therefore, people can apply to the court, or if someone goes with an application about the judgment review, revision, in the light of the exceptional circumstances, once again, the legislator provided for this opportunity if the decision hasn't been enforced yet based on that judgment. So once again, the retrospective application by the court is impossible, and it has to be applied and perceived only as an exception. It seems to me everyone has been at solidarity with us today, international experts likewise, the ones who have taken part in our today's workshop. Clearly, a judge has to adhere to the principle of proportionality, balance, just as Mr. Terletsky said that we have to maintain the balance between the public and private interests in each case. We have still many questions, but I encourage both our colleagues and Ukrainian colleagues to move from theoretical to practical plane of justice. That is to say, to try to implement retroactivity in practice in order to protect individuals and to restore justice. At this point, I thank you, and I would like to give the floor to give the wrapping up statements to Mr. Smokovich. But before that, just let me make one sentence. Okay, so for the final conclusions and the summary, Mr. Smokovich has the floor. Thank you very much indeed, Miroslava, for giving me the floor. I'm very thankful to all of the participants who have taken part in this event. I thank you for really taking the protection of human rights and freedoms so close to your heart. And I thank you that you worry about how administrative courts work in this plane. We do everything in order to protect the human rights effectively. Especially, I would like to give my thanks to Sergei Holovati, because here is the question about constitutional complaints, where a lot depends on our position on how weighty administrative justice and its decisions is today. But still, irrespective of that, Mr. Holovati, you have to continue considering constitutional complaints. This question that Mr. Holovati raised urges us to say and think that the Constitutional Court will have to render two types of decisions depending on the entity that applies to the court. And the judgments of the Constitutional Court in such cases, in their effects, will be more weighty, and it will be more applicable and applicable to a greater number of areas, because from the position of Mr. Holovati, retrospectivity is a must. Definitely there will be some problems connected with this, and those people who applied to court will have to go to court again. To the Constitutional Court, I mean. And the exceptional circumstance, they will have to base as a ground, as a reason, their applications on certain exceptional circumstances. And people will still have to be allowed opportunities to protect their rights and freedoms even before the Constitutional Court renders its decision. In other words, there will be a lot of problems interconnected, and we will have to deal with them, but to deal with them and resolve them in such a way that all of the citizens are satisfied and their individual rights and freedoms remain protected. At the same time, I really liked what Volodymyr Mykolaievich said. Something that I opposed at some point in time. When people want everything to become unified, homogeneous, civil, administrative justice, the same approaches they say need to be applied. But I'm deeply convinced that it shouldn't be the case for the administrative justice. However, nowadays, such an approach is in place. And definitely, let me also say to you that as of today, there are a lot of claims in district administrative courts. And I think that the judges are with us here and they are listening to us. And these claims, lawsuits, filed on the basis of Constitution 152 of the Constitution of Ukraine, which speak about compensating pecuniary and non-pecuniary damages in connection with the fact that the decision of the Constitutional Court found certain norms of the law on the judiciary as such that need to be invalidated. They were found, unfortunately, non-constitutional, and there it's in those norms it spoke about compensation. So there are a lot of judges who retired, and they filed their lawsuits with courts, and they would like these judgments to be reviewed based on the exceptional circumstances. I'm just giving you certain examples so that you understand how important the topic of today's workshop is. And I think all of the conclusions, opinions made today, that we heard today from our experts, trainers, and our keynote speakers, will have to be given a greater thought, taking into account their positions and certain regulators. They will definitely have to be applied when we try to resolve massive number of applications lodged with courts on the point that we have discussed today. So thank you very much indeed today for your participation. I wish everyone strong health, be healthy, and see you again. Sorry for the technical hitches. I think that today's evening has been exciting, and I thank the last speaker for his comments. Now, on my behalf, I understand that the final word of the president of the court has to be final, but still there is a certain nuance. Now I would like to thank on behalf of Mikhailo Ivanovich and all of the speakers who for more than 4 hours have been ensuring the process of our interaction. These are technical moderators. These are interpreters who have been fighting for the authentic rendition of the thoughts expressed today by the speakers. And all of the members of our system. I would like to thank the Secretariat members of our Administrative Cassation Court, who I wouldn't like to mitigate the role of other members of the Secretariat, but there were 3 ladies who have been so helpful in making sure that today's event will become reality. There were a lot of complexities, but the main idea was to make sure that this event goes down in history, and as many lawyers will be acquainted with your doctrinal approaches, because it will be beneficial and useful for both science, academic science, and practical application in order to ensure the protection of human rights, which is our main purpose. I would like also to thank the people from the central office who was able to organize and concentrate all of our efforts, and Mikhailo Smakovich, and international partners who we have seen personally on numerous occasions. I appreciate your patience, your perseverance, and readiness to help and to stand by Ukraine and embrace some of the ideas. Perhaps sometimes my ideas sounded odd and weird to you, but you have been able to help us to implement our workshop, and you have featured today the people of such a great stature, and you remain very kind friends of our country, and you continue to respect our approaches to how human rights should be ensured. Well, I wish you all good luck and a wonderful day. Goodbye.